May I be permitted to mention one matter, my lord? Not in the list. In fact, my learned junior wanted to mention it yesterday at 2 p.m.
If your junior wanted to mention, you should prefer that the juniors come. I usually do not entertain the seniors in mentioning at least.
But my lord, in this matter, my lord, but my lord, let my learned junior, my lord, mention this one is a very, very urgent matter. That is why, my lord, I am mentioning this matter. Urgent situation. Very urgent situation, my lord, I am mentioning this matter. If you lord, please kindly permit me to mention this matter.
Yes.
My lord, it is I am a dealer in a petrol pump. I was so caused. I had given reply. Hearing had taken place in January. They are supposed to communicate his decision within 45 days. Day before yesterday at night, they had sent me a mail that your so-called has been rejected. We are going to take position tomorrow. I said that you have given me notice now at midnight. Let me take instruction from my client, from my lawyer. Yesterday morning, they have ransacked the petrol pump, taken it position. Now they are going to give it third party. But in this situation, I have come before your lordships for your lordships protection.
File it.
May I just only seek your lordship's indulgence tomorrow, subject to your lordship.
Will you be able to serve in the meantime?
I will.
Very well, tomorrow.
Please,
Item number 399, contempt application of today's list. There is some urgency, they are constructing illegal construction. Any time of today, I'll give notice to the other side.
Yes.
4 p.m. 399.
399. Take a note.
My lord, may I permitted to mention one matter which is in the monthly combined list of your lordship as hearing matter 180. Your lordship heard the matter. It is regarding my termination of my tender after giving me with a tender. Now they are during the pendency. Now they are yesterday at 4:22 p.m. my lord, they are invoking the bank guarantee of my lord 12 lakhs. My lord, if this court has not vested them, my lord, because the 8th is the date.
Why don't you come up with a small application?
I am with a supplementary affidavit. I am stating
supplementary affidavit. In the affidavit, you cannot make a prayer. Had it been an application format, then the prayer could have been there. The court could have entertained
my
it.
lord, I may, if you lordship kindly give me leave that move this application at 2 p.m. My lord, I change it to the application and my lord,
Today 2 p.m. without service, how can it be done?
My lord, because Mr. Mahato is appearing, I have already.
Maybe, but he needs to take instruction. Your client has given you instruction. Mr. Mahato doesn't have instruction. He need to take instruction.
What happened, my lord, yesterday night, my lord, so far this matter, my lord, I am my lord, giving notice to Mr. Mahato that I will mention the matter tomorrow before his on ladyship. I have given that notice, my lord. With notice, I am mentioning, my lord,
yes.
If this matter, because my lord, it is in the combined is 1803. If your lordship kindly take the matter at 2 p.m., my lord, that can be.
Tomorrow is Friday. I take up hearing matters 1803.
Yes, my lord.
1803 to list the supplementary list.
Because my lord, is the date for invoking the bank.
Yes, my lord. Intimate Mr. Mahato that tomorrow it will appear. Slip is not required.
My lord, may I permit you to mention?
No, please. Today is not the date for upgradation.
My lord, may I permit you to mention item number 294 of the today list, my lord.
Why?
The urgency that, my lord, the petitioner is pursuing this matter since 2003, my lord, before this honorable court only for the correction of record of right, my lord. My lord,
correction of record
of right, my lord.
The High Court.
Yes, my lord. In compliance of the civil decree, my lord. My lord have directed the BLRO to correct the record of right, but they have not complied, my lord. The petitioner, senior citizen, my lord.
Is it contempt matter?
Yes, my lord.
Item?
294, my lord.
Bring your other side.
My lord, I will serve notice upon them.
Serve notice is not the last thing. I want to see your other side over here. I want to hear the submission of the other side.
My lord.
Then only it will be possible.
My lord.
Yes.
294.
353 item number. This is matter relates to appointment of the Muslim marriage register. The interim order passed. The Miss Chaitanya Bhattaji is appearing for the petitioner. Due to her treatment, he was in the Chennai. Matter appear somehow not notice. I filed a restoration application. And in another matter, my lord,
I am not.
my lord, upon
Restoration, it will be
my
there.
lord, in another
Not
matter, my lord passed an order in the search of another repetition. My lord passed an order since until unless the steps has been taken in the restoration, they have a right to proceed.
Yes.
In this matter, my lord, so kindly take up, my lord, this matter, my lord. Otherwise, my lord, the interim
The matter is dismissed.
my lord, I have filed a restoration.
Your
application.
filing will not do. See, if you know that your matter is urgent, then steps should have been taken in proper time.
My lord,
This way you let the matter get dismissed and then you come up with urgency, it has to be restored.
my lord,
The
upon
court has
notice-
to manage its own business. Sorry, sir.
My lord, may I
Do not mention.
My lord,
My lord, with regard to item number 365, your lordship's daily list, my lord, the content application, my lord, rule has been issued. There's a direction to restore the water body. Nothing has been done, my lord. Rampant construction is going on. I have served notice to the other side. Mr. Alok Ghosh is appearing for the contempt, my lord. Let it be taken up today, my lord.
Item
365, my lord.
365. Take
My lord, may I
may I your lord?
original side matter, my lord, for inclusion of name, my lord. My name is not included in the final order.
My lord, may your lordships kind leave to mention item
Lord, to mention, my
357,
lord,
my
item
lord.
number 171, my lord, of today's list, my lord, going to my lord, contempt application, my lord. My lord, do we have served, my lord, the contemnants, my lord, thereafter, my lord, the contemnants are not, my lord, appearing, not taking any steps, my lord, for completion of the hearing, my lord.
Please, the matter is there in the list. Not
My lord,
mentioned.
I have your lordship's kind leave, my lord. To my lord, item 266 of monthly list, my lord, what has happened, my lord, the helpless lady after.
No, 266 monthly list. I'm not going to listen. All upgradations were accepted. No questions asked. So today, nothing.
My lord, there is an urgent.
Sorry, cannot help. You should have come on Monday. Yes, madam.
I have given the inclusion in list last Monday, but it is not appeared in the list. My lord,
It cannot be done within a day and two. You have to give time.
My lord, random.
I am a housing finance company, my
What
lord.
do you want?
A writ
Is there-
petition is filed, my lord. Restraining order, your lordship has passed on 11th February. My
Yes,
lord, affidavits are complete. I've taken out a vacating application,
right.
which is appearing at 357. My lord, the HFC has been restrained for the past 6 months. I'm kindly
Sir,
pitching,
vacating
your
cannot
lordship-
be taken up.
my lord,
Please do
kindly,
not
my lord, next
mention.
week, my lord, next
No, you have to wait for your turn. Yes.
Contempt application, I will bring Mr. Srijan Naik. It's a electricity matter, new electric connection. I will bring Mr. Naik.
300?
411.
411. Bring.
I have come up with a very innocuous prayer, my lord. One writ application is lying before your lordship at item number 246. So I had the private respondent on those matter, lordship. Now now when the order was passed, lordship, I was unrepresented because service was not completed on that day when the order was passed. Now it comes under the heading of contempt application. They have filed on contempt application. So I am instructed to take up a review application to this matter, lordship. Now to filing the review application, I have to obtain the certified copy. Because the matter is lies before your lordship, so I can't obtain the certified copy, lordship. If the direction may be given that it will go for
Which item?
item number 246, lordship.
All right, 246.
I
It
have
will go down to the department and it will come up.
Lord,
All right.
item careful.
item number 245, your lordship may remember, on the last Thursday, my lord, this matter was heard by your lordship, my lord, and upon my mentioning, my lord, this matter was upgraded matter, my lord, and my lord, the Bidhanagar, my lord, municipal corporation, my lord, Shishana Bandhavadya, my lord, took time that they missed the file. That's why, my lord, your lordship was adjourned this matter on that day. And this matter was supposed to come as updated matter on 245. But
45 of today's list.
today's list, my lord. This is content matter, my lord. Your lordship may remember that your lordship, I am mentioning this matter was updated 199 on the last Thursday, and this matter has gone down in the this mail. They took time.
245 একটু দেখবেন যদি এরকম ডিরেকশন থাকে উপর দিকে তুলে দেবেন
That may be
My lord.
permitted to mention item number 424 to 425 of daily list as an application. Mr. Chatterjee, Orindam Chatterjee is for my his other side, my lord.
What is the matter?
Relating to, my lord, pursuant to work order, my lord, petitioner completed the work, my lord, work completion certificate was issued 2 years back, but
Payment has not been made.
yes,
Payment not made.
yes, ma'am.
So, which item?
425.
425.
425.
What is
Application.
the application for?
application, my lord, dismissal, my lord, restoration, my lord.
Restoration. So you got the matter dismissed.
My lord, on my fault, my lord.
425. আজকে বার করে রাখবেন।
May I be permitted to mention the item number 70 and 73 of today's list, my lord. They should have been appearing under the heading of payment of dues, my lord. But 70 and 73 of today's list.
70 and 73.
Madam, Mr. Bakshi has already mentioned this matter before your lordship.
70 and 73. Yes, payment of dues.
Deeply.
Item number.
Tomorrow it will appear.
Yes.
My lord, item
Madam, may I?
No slip.
Item number 420, my lord, restoration application, my lord, concerned bank deducted my salary account, my lord, on a certificate case.
You were not there. The matter got dismissed. What can be done?
My lord, I serve copy upon.
Your serving copy will not do. Wait.
Yes. May be permitted to, my lord, mention one extreme urgent matter, my lord, where the private respondent, my lord, who are belonging, my lord, the OBC category candidate, are, my lord, taking away the seats of the petitioner who is an economically weaker section candidate by showing himself to be an EWS candidate. My lord, this matter is, my lord, unless your lordship, my lord, takes it up, and if, my lord, this issue is not resolved, my lord, my scope, my lord, to be engaged in this, to be, my lord, included in the medical courses, my lord, will go. So I just beseech your lordship.
But then EWS has got a different vacancy. The the reservation for the
members, my lord, this kind of matter was previously taken up by the
yes.
Supreme Court. My lord, they are, my lord, taking plea of the Honorable Supreme Court staying of the order of this Honorable Division bench.
Yes.
That since OBC category candidates, this particular, there has been a stay. So this is why we can right now, you can right now regard ourselves to be an EWS. By taking this plea, my lord, they have been taking the benefit of EWS in spite of being the OBC, which they cannot do as per the Constitution.
It has to be heard, sir. It cannot be done in this way.
If it could be, my lord.
No, it cannot be done.
But,
call the list, please.
My lord, one indulgence.
Yes.
You know, the advocate on record, he's not yet here with the mentioning slip. And this motion was supposed to appear today. So urgency is that it relates to the deactivation of the petitioner's Aadhaar card. So we have filed this petition on 6th. It was supposed to appear today, but it has not appeared. If it could be listed, my lord, and
it will appear. Since it has been filed, it will appear in usual course.
Grateful, my lord.
Yes.
My lord, I appear, my lord, for, my lord, the petition.
Talks of settlement were going on?
Yes, my lord. My lord,
has it matured?
My lord, it has come very close. My lord, I just want to indicate to your lordship.
Not at all.
You want more time?
No, my lord. Now it's come to a point where, my lord, we need your lordship's intervention.
Then what is the settlement?
My lord, we've reached, my lord, really close, my lord. I'll just indicate, my lord. Very close. My lord, I'll give further suggestions before your lordships, my lord, so that, my lord, they can also, my lord, take instructions. My lord, this was, my lord, an e-tender floated, my lord, by the port authorities for grant of a 30-year lease of the land. My lord, a tender also provided that, my lord, a structure which had been constructed, my lord, by Mr. Basu's clients, my lord, my lord, on that land, my lord, the consideration for that had to be paid, my lord, to Mr. Basu's client.
You are for the respondent number?
5. Respondent number 5.
Yes.
And, my lord, they had a right of first refusal to match, my lord, the highest bid. My lord, we bid, we were the highest, they could not match it. So, my lord, we became entitled to, my lord, succeed. The port, my lord, gave us, my lord, a letter of allotment. Now, my lord, 4 things they did not provide, my lord, 4, my lord, in the letter of allotment. One was, my lord, the date of commencement of the lease. My lord, I have to get possession. My lord, I said date of commencement of the lease. Then, my lord, second thing they did was, they said, my lord, that GST would have to be paid, my lord, on, my lord, occupier share of municipal rates and taxes. Third thing they said was, GST has to be paid for, my lord, the value of the completed structure. And, my lord, fourth thing, my lord, which they, my lord, did, my lord, was, my lord, they did not, my lord, actually, my lord, make, my lord, any provision, my lord, within which, my lord, the occupier of the structure, my lord, would vacate. So we said we are agreeable to everything, but we have certain points to make, which were not even in the tender. My lord, first is, my lord, GST, my lord, on the structure, my lord, question doesn't arise. We cited the relevant provisions of the law. Second, my lord, we said, if we are buying the structure, we must have a conveyance to that effect from, my lord, the owner. Third, my lord, we said that, my lord, lease can only commence, my lord, from the date, my lord, we, my lord, get possession. And fourth, my lord, what we, my lord, indicated was that, my lord, the occupier share of municipal taxes has to be, my lord, as per the present municipal rules. It can't be what you're calculating. It can only be on the basis of what you're paying. And 50% of that, my lord, we are willing to pay for that portion of the land. There's no difficulty. My lord, the other thing we said is, there cannot be GST, my lord, on, my lord, the occupier share of municipal taxes. Because it's, my lord, a tax on tax. My lord, this is where we were. My lord, there was, my lord, nothing happening from the port. But, my lord, the port ultimately got back, my lord, to several letters which we had written, saying, yes, lease will commence from the date of possession. But date of possession was not indicated. And, my lord, they insisted on all the GSTs. So, my lord, we had moved, my lord, the writ petition before your lordships. My lord, immediately after service, my lord, of the writ proceedings, my lord, the port, my lord, got us together. And, my lord, along with, my lord, respond number 5 and the petitioners. My lord, I have just prepared, my lord, a 2-page chart as to where we are, so that, my lord, we can, my lord, try and, my lord, resolve this issue. My lord, the other side. My lord, the first 3 entries, my lord, relate to, my lord, the, my lord, annual rent and, my lord, the, my lord, deposit, my lord, which has to be made. My lord, kindly see, it has 3 components. My lord,
But first of all,
yes,
you have to be satisfied that the private respondent leaves the place, vacates the place. Otherwise, you cannot enter.
correct. So they've agreed. My lord, it's come to that. My lord, I'll show, my lord, we moved. My lord,
More than that.
yes, my lord,
Beyond
we have
that.
moved.
All
My
right.
lord, kindly see. My lord, the first 3 entries,
yes,
my lord, we have no problem, my lord, in paying this. My lord, 1, 2, and, my lord, 3. Except that, my lord, the occupier share of municipal tax on land and structure plus GST thereon at the rate of 18%, my lord, is, my lord, where we have a problem. Because this is, my lord, the subject of challenge. It's a question of law, my lord, which, my lord, your lordships can decide. But I'm willing to put in, my lord, this entire amount in court. I don't have a problem. It's, my lord, 80,50,000. Now, my lord, comes, my lord, the fourth. My lord, valuation of structure plus GST at the rate of 18%. My lord, here, my lord, the respondent number 5, Mr. Basu's client, has agreed, my lord, because the conveyance is to be executed by him, that, my lord, no GST is payable on the structure. Port has said, my lord, that's between us. They don't have, my lord, an objection. So, my lord, I am, my lord, willing to, my lord, pay this amount, my lord, of 18 crore 66 lakhs 42,000. My lord, all that I had insisted on, my lord, was, my lord, this will be paid along with the conveyance. And, my lord, we can, my lord, execute the conveyance, my lord, send them a draft, my lord, by Monday. My lord, and, my lord, once they approve it, against conveyance payment. Just one minute, please. Now, my lord, they say, no, you take possession and before possession you pay, we will execute the conveyance. Now, my lord, your lordship knows, my lord, generally real estate transaction, my lord, entire payment is against the conveyance. But I want to go a mile further, my lord, before your lordships. My lord, which is, my lord, I will make the payment before execution of conveyance. But, my lord, there should be first an undertaking to court that they will execute the conveyance. And, my lord, before, my lord, I make the payment, my lord, I must have, my lord, a valuation report which they've agreed to give, the sanction plan and the completion certificate. I have, my lord, the documents on the basis of which they have agreed to this, my lord. So they should, my lord, give it to us before we make the payment. And within, my lord, a particular period of them making it available, I'm willing to make this payment and conveyance, my lord, can be executed. Now, my lord, kindly come to, my lord. Yes, and, my lord, the payment, my lord, will be made as they agreed, my lord, against possession. I pay and they hand over. So, my lord, the port must be in a position to hand it over, because the tender conditions say that, my lord, they will make over this structure to the port, who will then hand it over to us. Now, my lord, comes, my lord, the next page, my lord, item 6 and 7, my lord, which I'm willing to, my lord, pay. My lord, the valuation report, I have to pay for it. My lord, the figure as per the tender documents is 26,123. The lease formatted forms, my lord, I'm willing to pay 4,012 rupees. Now, my lord, the security deposit, which I have to pay, because, my lord, it's an annual rent over 30 years. My lord, we are willing to, my lord, deposit this amount. And, my lord, subject to, my lord, adjustment of whatever security deposits we made with the port. And in the comment section, I've given, my lord, the relevant portion, my lord, of the tender documents which provide for, my lord, this adjustment. So, my lord, in effect, my lord, I am, my lord, willing to put in the entire money. But, my lord, I must know, my lord, that what I'm buying has a sanction plan and it is a completion certificate. I'm not disputing the value, but, my lord, I must know it because that's what I'll provide in the conveyance. And, my lord, before conveyance, I will make this payment. But, my lord, after getting, my lord, the sanction plan, and now, my lord, kindly see the star. My lord, this I've diluted now because of my submissions. All payments to both SMPK and DIVAS to be made simultaneously with execution for lease for land and conveyance for structure and handover of so. So, my lord, I'm not insisting on conveyance, my lord, now. And, my lord, lease they'll have to execute. Tender provides, my lord, that I will make the initial, my lord, payment and they will execute the lease. I don't have a problem. I'm sure the port will execute the lease.
All right.
My lord, this is, my lord, my lord, suggestion, my lord, humble suggestion. My lord, before your lordship.
Mr. Bose. Lord, I am the port authority. My lord, I'll just, Lord, kindly see the first the tender, then my lord, kindly see the addendum to the tender.
Page.
Lord, I am willing, I'm not being able to appreciate this. I am willing.
All
You
right.
have participated in the tender.
Yes.
There is an addendum to the tender. Post the addendum, you've accepted and made an offer. Your offer has been accepted. So, my lord, the willingness, my lord, I'm not being able to understand before the rate code what is the willingness. Either you accept it or the consequences will follow. My lord, the terms and conditions of the tender and the addendum will follow. My lord, kindly have a look at page 110, which is the addendum.
Yes.
My lord, the only addendum to the original terms was, my lord, the valuation of the structures.
Right.
My lord, initially the valuation was, my lord, 10 crores 54 lakhs. Thereafter it was enhanced to 18 crores 66 lakhs.
Yes.
So based on this addendum, they have participated and they've made the offer. Your lordship will find their offer letter at they participated in the tender, and on the basis of the tender, the KOPT had issued them the offer letter, which is at page 113, 113.
Yes.
So now, after we issue the offer letter, after his participation, my lord, he responds by a letter of 4th April.
Was there a time period within which the offer was to be accepted or something?
Yes, my lord. So there is no, when I give, he's already the highest bidder. So the first right of refusal was with the existing lessee. The existing lessee did not exercise their first right of refusal. So it is Mr. Mukherjee's client. Thereafter, when we give the offer letter to him, that your offer has been accepted. These are the terms in accordance with the NIT, terms of the NIT and the addendum. So after I give the offer letter, this is the response which comes from them. Well, it also will not kindly have a look at once page 115 once. Well, what just fell from your lordship, well, this is
30 days from the date of
yes,
issuance.
yes.
Hmm.
Clause 8. Now, my lord, here, now, my lord, lordship will kindly take their response at 4th of April. 4th of April, page 125. Well, they first complain of the valuation, which from the submissions of Mr. Mukherjee, I understand that they don't have any further grievance so far as the valuation is concerned.
Yes.
Because they have participated knowing very well that the valuation is now 18 crores and not 10 crores. And my lord, in any event, it was the original terms of the tender was as is where is basis. Now, my lord, so far as there, my lord, kindly take clause, paragraph 7. My lord, kindly take paragraph 6 first. My lord, GST, my lord, so far as GST is concerned, The GST, if applicable, if applicable has to be paid. If not applicable, they don't have to pay. Now it is with the GST authorities. Under section, under section 7(2)(a) on immovable property, sale of immovable property. If it is payable, they have to pay. If it's not payable, so it doesn't concern me. So far as that's our stand on GST. Now, if your lordship now kindly comes to paragraph 6.
Yes.
Now we have told them that so far as municipal rates and taxes, you are going to be the lessee now. Now they are going to be the occupier pursuant to the 30-year lease which will be granted to them. So they are required to pay municipal rates and taxes. Now what they say is paragraph 6, that you have desired payment of occupier share of municipal tax on land at the rate of 20.25% on yearly rent. Please note that Kolkata Municipal Corporation is presently insisting on payment of municipal tax under unitary assessment system. Our liability for occupier share of municipal tax is 50% of the total municipal tax and would be much less than 20% of the yearly rent. My lord, the first is, if your lordship kindly takes the Municipal Corporation Act, as your lordship is aware, my lord, under the unitary assessment, it is now a possession-based tax. Under section 196, it is a person who's in occupation is entirely liable to pay the tax, 100% of the tax, not 50%. My lord, this was under the my lord, the rental system, where my lord, there was a share of municipal taxes between the landlord and the tenant. My lord, under the unitary assessment, which is, my lord, under section 174 and 179, my lord, the entire tax is required to be paid by the occupant. He is the person who's primarily liable for payment of tax. Now, my lord, kindly see, so far as our tax structure is concerned, my lord, kindly take section 171.
No, why should we go into this at this stage?
My lord, this is the point raised by them, not the subject matter of the writ. So what I am saying is, municipal tax is based on the act. So I don't take the municipal tax. Corporation takes the municipal tax. I collect and pay to the corporation. What we are saying is that, my lord, there is a provision under the act, but which,
whatever is the provision, the occupier who will step into possession will take steps.
yes, so my lord,
that is all right.
there is
then
there is a exemption so far as port trust lands are concerned under the act itself.
All right.
So this land being a land of the port authorities, so it comes within the purview of section 171.
All right.
Well, there that subsection says,
No, it's all right. Thing is, handing over a possession. Handing over a possession.
Yes. First, they have to pay.
They have to
pay for the structure.
Yes.
Once they pay for the structure, well, the conveyance will be made by the private respondent in favor of Mr. Mukherjee's client. Thereafter, possession would be made over. He will vacate and make over possession. Through me, they'll get possession. So unless they make payment, well, these riders and conditions on the, because I have given them based on the terms and conditions. These conditions cannot be, it will alter the terms of the tender. So, well, under section, your lordship can make a note, well, under section 171, subsection 7
the court is not making
of
any
the
note.
KMC Act, well, it
nothing.
provides the manner in which I am required
want
to
the
assess
money?
the tax.
What is the prayer?
You want the money and you'll leave.
Then pay.
Yes, thing is,
Not the ploy not to pay.
this is what I was trying to think. Why the writ petition? What is the writ petition for?
This prayer can be made. Can you come to page 44?
Yes.
Can you come to prayer C?
And most of their,
Yes. Can my lord grant this prayer? Very well. The concluded contract between the port trust.
Whatever is, yes, there is an offer. You accept it. Whether you accept, whether you, it's what is to be done here. I was just wondering. You do not have any objection. You take the money and you leave.
Get the money.
You
time thereafter.
For execution of the deed and everything.
My belongings.
All your articles over there. Make payment.
I will make over possession. GST authorities, KMC is the tax under section 177(7).
I do not know why this writ petition. Everybody is agreeable.
Correct, my lord. So, my lord, let us sit and come back to your lordship. The lawyers sit and come back to your lordship.
What is the use of sitting? You pass on the payment, all
My lord,
steps.
may I tell your lordships, my lord? What your lordship has not been told, my learned friend Mr. Bose, my lord. Mr. Bose has, my lord, very clearly shown your lordship, my lord, my response to the allotment letter. Kindly see what he asks for in the allotment letter, which is not in the tender. Kindly now, my lord, come to, my lord, the allotment letter. 10th of March, 2025. That's why we came to court. Page 113, my lord.
Yes, 113.
This is the allotment letter.
Yes.
Now kindly see first. 2, payment.
Yes.
Now, my lord, option 1. That is what we have, my lord, 114, my lord.
Yes.
There are 2 methods. We've opted for option 1.
Yes.
My lord, on annual rent basis, 4 crores 10 lakh 90,000 rent for first year and occupier share of so-and-so on so-and-so plus GST at the rate of so-and-so. Now, my lord, this 20.25% on yearly rent plus municipal tax on structure if applicable. My lord, is this, my lord, provided in the tender?
Or is it not?
No,
Whatever
It
is
is in the act. Kindly read
whatever
section
is
170.
1 minute. Whatever is the provision of law pursuant to which, relying on which a payment is to be made, you'll pay.
Correct, but they are asking for this payment.
Applicable law has to.
My lord, this is, they are asking for this, and we are saying it is not so. Oh, that's all, my lord. I am willing to put in, my lord, this
Yes.
money in court.
This little bit of thing
Lord,
can
may
be
I
taken
just
care of.
clarify? My lord, may I just
Whatever is
clarify?
there in
May I
the
just
act, it
clarify?
will
Lord,
follow.
will kindly give me a minute, I'll clarify. My lord, section 171, subsection 7, my lord, makes it, there's a separate distinction made to land owned by the port authorities. In terms of that section, there is an agreement.
Please sit.
I have
and
done
let
that. I have given them the details. There is an agreement between the port authorities and the municipality, which is at least 50 years old. In terms thereof, the annual rental, 40% of the annual rental based on the particular slab, because this is the highest rent. So it comes under the highest slab. 40% of the annual rental is the municipal tax payable. So half of which is 20%. And 0.5% is Howrah Bridge tax. So that is 0.25. So that comes to 20.25. So that is exactly what I've charged them. That is 50%.
Please, I think it can be resolved. There is nothing for the court to decide. Please come.
It is not our forum.
Acha. Pursuant to a notice inviting tender floated by the Shama Prasad Mukherjee Port, the petitioner submitted its bid and emerged as the highest bidder. Stop. An offer letter has been issued in favor of the petitioner. Stop. The petitioner is required to make certain payments. Stop. The petitioners raise issue with regard to the municipal tax that has been required, that has been directed to be paid in the offer letter. Stop. According to the petitioner, the tax rate that has been mentioned is not in accordance with the municipal laws. Stop. Paragraph. The parties are directed to sit across the table to crease out any differences that have cropped up. Stop. The matter is made returnable. Fortnight will be all right with y'all.
My lord, my lord.
21st.
My lord, only one indulgence, my lord. Kindly record my submission on the tax part. Otherwise, will it become difficult?
Municipal.
That, my lord, my submission is that the tax is being charged in accordance with section 171, subsection 7 of the Kolkata Municipal Corporation Act 1980.
According to the Port Authority, the municipal tax is being charged in terms of section 171, clause
Subsection 7.
7. 171(7) of the KMC Act 1980.
My learned juniors in some difficulty, my lord, kindly, my lord, 20th is possible.
20.
If
20th.
obliged. My lord, maybe, my lord, we filed affirmed a supplementary affidavit which we have served.
I say writ is not maintainable. They can say supplementary
No,
affidavit.
my learned friend will consider it. This might make the writ applicable.
Cannot be at all.
Very well. It's taken on record. Copy to be served.
Yes, we've done that, my lord. Well enough.
Yesterday night.
Item number 2. Intervening this petition.
You are intervening.
The respondent number.
Have you come up with an application?
No, I need
Lordship.
the copy. So my lord may direct the.
Why? Who are? Let me hear the petitioner.
Lordship,
Whose officer?
for the respondent number 224, I am seeking for only 1 day accommodation.
1 day. Who is the petitioner?
I am the petitioner. Well, I am.
CBI has registered the FIR and they have not made party CBI. So
No, it is.
CBI.
But
CBI has succeeded against the present petitioner.
that is fine, but this
There
is,
may be other issues. You know, you never know. It may not be relating to the CBI.
I have got instruction from CBI, BSFP, Kolkata that to act.
Please listen and hear what the petitioner has got to say, and then you can make submission, whether it relates to CBI or not. Please hear. Wait here, sir. Yes.
this is a willful default challenge, my lord.
All right.
On the ground, my lord, that show cause notice, identification committee order, and my lord, the review committee order are more or less, my lord, on the same lines.
Yes.
So that shows, my lord, non-application of mine.
All right.
Second is, my lord, no documents given. But the first issue is the principal, my lord, argument. So, my lord, if your lordship feels that CBI should be given.
Bank. Where is the bank?
I am for the bank, Lordship.
Yes.
I am seeking only 1 day accommodation. Actually, my senior is engaged in another court, Miss Aparajita Rao.
All right.
Let me then come on Tuesday if your lordship.
Next Tuesday. All right.
Maybe on Wednesday.
Please come.
appear for the Reserve Bank.
Because we need the copy. CBI has registered FIR against the present petitioner.
But that
And
does
they
it have,
already been charge sheeted.
that's fine, my lord, but that has
That
nothing to
must
do
be a
with.
criminal proceeding. What has that got to do with the willful default?
So, my lord, CBI has instructed to intervene in this matter.
There must be a reason for intervention.
CBI has registered the FIR and charge sheet against the present petitioner.
Proceed accordingly. Who is stopping you? Is anybody stopping you?
I am asking a copy, maybe, sir. We need the copy, maybe. That is the difficulty.
You can get this copy from some other source also, assuming the petitioner does not give it to you and the court does not direct the petitioner to give it to you. You know how to get it. Then, Acha. Learned advocate representing the Punjab National Bank seeks accommodation. Stop. Next. The petitioner has been declared as willful defaulter by the bank. Stop. The same is under challenge in the instant writ petition. Stop. Violation of principle of natural justice has been pleaded. Stop. To allow the learned advocate representing the bank to come ready with proper instruction in the matter. You want it on Tuesday? Wednesday? Wednesday, 13th. 13th is Wednesday.
Look, if your lordship wants, I'll give him a copy. There's no hide and seek from, at least from our side.
Up to you.
Otherwise, he'll file an
The
intervention and
court-
delay.
The court is yet to know what the matter is about. You said willful default. I have
Yes.
recorded willful default. I do not
That's
know.
all. Milord, what I'll do is I'll give him a copy so that this problem doesn't arise. Is there a copy though? I know.
Thank
Yes, next.
you.
You are for the respondent?
Point out that this is arising from the eviction process under public devices. That would go to code 70.
This bench doesn't have determination.
At page 19, there is an eviction order of the writ petition.
Where is the petitioner?
The petitioner is not.
Not here. Last occasion, nobody for the respondent.
At page 19, there is an eviction order. And
None appears for the petitioner. Stop. Learned advocate for the port authority submits that this bench does not have determination to decide the issue. Stop. To allow the learned advocate for the petitioner to respond to the aforesaid contention. Hearing of the matter stands adjourned till next Wednesday, 13th.
I am grateful.
I appear for the petitioner.
Yes.
This is with respect to incentives, my lord. This is my 7th round of writ petition that I have filed. My lord, this is pursuant to an order passed by His Lordship, Honorable Justice Shobhushachi Bhattacharya. Lordship will kindly see the order first, my lord, at page 189.
189.
In the second volume, my lord.
Yes. Are you aware that a act has been promulgated by the
Lordship,
state?
I am aware, but in connection with the same writ petition, an appeal is going on, and Lordship is hearing with respect to implementation of another writ petition. And that in that appeal, the Advocate General is supposed to take instruction and make his submissions.
All right.
So that is, between the same parties, my lord, but that's a different scheme, and this is a different scheme.
All right.
So my lord,
Yes.
that is why, my lord, unless that submission is made, Lordship, we cannot do. But my lord, this is different. This, my lord,
What is
at
your
page,
prayer here?
Lordship, page 189, my prayer is,
189.
my lord, for registration of my, for amendment of the registration certificate under this scheme. But my lord, as I said, this is the seventh round of writ petition. In one of the rounds, my lord, Justice Bhattacharya has said that, which is the order is at page 189,
Yes.
that a hearing should be given to us. And in the event any other objection is given to you, that should be informed to us, and we shall write to them saying that this is our reply, and then a reasoned order should be given. And in that order, Lordship, the earlier reasons which were given by the authorities, those were discarded, saying that those points cannot be taken. Lordship, without giving any opportunity to us, Lordship, we complied, and a hearing was given. But my lord, in the hearing, whatever was discussed, when the order comes out, new points were taken for rejection of my prayer.
That is the
The
challenge.
old points which were already rejected by Justice Bhattacharya, those were also taken.
That is the challenge.
That is the challenge, my lord.
Who is your other side?
Mr. Mr. Chakraborty was there yesterday. I saw him.
Tanay Chakraborty.
Lordship.
Today nobody is here. Show the impugned order, please. Where is the impugned order?
Lordship. Lordship, kindly see page 214. So while hearing my application for amendment, they rejected my registration certificate altogether. So that is, and again, something which in Justice Bhattacharya's order, it was
Is
mentioned that
not
cannot.
eligible for registration certificate under the scheme, and hence the registration is cancelled. The scheme is of the year 2004. In 2024, they go and cancel your registration certificate.
Yes.
When was this issued?
This
certificate,
order,
registration certificate?
registration certificate was long back, madam. The original was issued in 2006.
2005 possibly, and hence the registration issued
So
4th
2006 is
March
amended.
2005. Amended 20th January 2006 is hereby cancelled and revoked.
Yes. So if
And in the meantime,
Bhattacharya
the
has-
benefits, so whatever you got was sought to be revoked.
see, repetition for the benefits. You're not getting anything. Lordship kindly directs.
The recent order passed by the Director of Industries, West Bengal, dated 30th October 2024, cancelling the registration certificate issued to the petitioner on 4th March 25, amended on 20th January 2006 under the West Bengal Incentive Scheme, 2004 is impugned herein. Stop. None represents the respondents. Stop. Next. The matter has to be decided upon exchange of affidavits.
No, the affidavits, only the report will do, my lord.
Report?
Affidavits are not required.
Okay,
Lordship,
ठीक है,
we'll keep it on Tuesday. We shall issue a notice on them again.
A report is required from the end of the respondents, disclosing reasons for cancellation and revocation of the certificate, which was issued nearly 20 years back.
The respondent number 2, my lord. detail.
Paragraph, the respondent number 2 is accordingly directed to file a report by way of affidavit. File it jagah, prepare and circulate by 22nd, released 27th. Next matter is also same.
No, my lord. Next matter.
Oh, it's different.
I'm led by Miss.
Yes, please.
But here in this case, my lord, I executed a deed of gift in 2017
In favor of?
in favor of my grandmother.
All right.
In 2017, my lord, I
Yes.
sought for assessment of the stamp duty in terms of Article 33I in Schedule 1A. I was told that I am supposed to pay 1.5% of the market value. My lord, I paid that as stamp
Are you
duty.
not representing the state now?
But I have resigned.
When?
No, my lord, is on 25th of July.
Yes. Hmm. Who is the other side?
I do not know, my lord. We have
Do not know.
We have already served. We have
All
already
right.
served. My lord,
Yes.
Since 2017, I have been running from pillar to post. I'll tell you, Lordship, my lord, what I have done. In 2017, I executed a deed of gift. When I went for collecting my deed of conveyance, deed of gift, I paid the stamp duty user charges. My lord, they said the ARA 1 raised an objection. No, you have to pay stamp duty in terms of the conveyance. That is Article 33(2) of Schedule 1A. That is
Deed
6%
of
of the
gift.
It was a gift.
Blood relation.
Blood relation. I gifted it to my grandmother.
All right.
And it comes within the definition of family in Article 30. I'll
Yes.
show to your lordship.
Yes, yes. Yes, then?
My lord, thereafter, in 2017, when I executed the deed of gift, nothing happening. When I went there, ARA raised objection. I preferred a writ petition before this honorable court.
Yes.
In 2017 itself, if your lordship kindly looks at page 50, my lord Justice Boshak was pleased to hold, my lord, that it is a deed of gift between the family members, taking into consideration the definition of family in Schedule 1A, and directed the concerned authority to register the deed of gift and give it to me.
Yes.
They did nothing to that.
Right.
But only that, my lord Justice Boshak did not give any specific timeline. But thereafter, my lord, I have been making correspondence to them.
Hmm.
A continuous correspondence, my lord, they do nothing. I am told that they preferred an inter-court appeal in 2017 itself. They never took any steps against that appeal. In 2019, it was dismissed for default. They filed a restoration application. They never took steps to get the restoration application heard. The matter still remains dismissed for default since 2019. My lord, I am running from pillar to post. I have been making correspondence to them. They say they kindly hand me over the copy of the order of my lord Justice Boshak. I did that also. My lord, they are not handing me the copy of the deed of.
Please come. The matter relates to execution of a deed of conveyance.
A deed of gift to be present.
Acha. Deed of gift. Stop. The matter was taken up for consideration by the court in the earlier writ petition filed by the petitioner, being WP 8854 within bracket W of 2017, and video order dated 28th March 2017. The court directed the registering authority to proceed to register the deed of gift presented for registration by the petitioner on the basis of Article 33 within bracket small I of Schedule Roman 1 caps A of the Indian Stamp Act, 1988. Stop. The said order is yet to be acted upon. Stop. Paragraph. None appears on behalf of the respondents. Stop. The Additional Registrar of Assurance Roman 1 Kolkata is directed to file a report by way of affidavit. File it jayega, prepare and circulate by 22nd August as to why the order of the court has not been acted upon till date. Stop. Released 27th. Let the aforesaid order be communicated to the learned advocate representing the state respondents.
The Indian Stamp Act is of 1899.
It's 1899.
In 88, my lord, there is a
All right.
Get from
No further order. ওটা কত ছিল?
23
আচ্ছা।
My lord, I am for the petitioner, my lord. My lord, petitioner give the instruction to
Give.
withdraw the matter.
Not pressed. Written instruction taken on record. Next.
Great, my lord.
Appearances.
Grateful.
Please see your lordship's last order on 28th of July 25 on the second page.
Respondents were directed to file a report.
We have received a copy of a report.
All right. The report shall indicate as to whether the encumbrance-free site was made available to the contractor, the date of handing over drawings, progress of the contractor, and the payment made. Are all these details mentioned?
Not three things have been mentioned. One is mutually inconsistent with the other.
All right.
Not one thing was not pointed out to your lordship on the last occasion, but in fact in 2022 they decided to reduce the construction activities from a G+7 storied building to G+2 storied building.
From 7 to 2?
2.
Yes.
Therefore, the decision remained inconclusive. And now to say that we are in breach of the contract for the purpose of execution of work is too far-fetched on the part of the government. In 2025 only things have been finalized. In 1 month's time, levy of compensation and termination. Now let them come and kindly permit me to use an exception to this report. And all irrelevant things pointed out. Your lordship's order is very specific. Now, two things your lordship wanted to know. Paragraph 7.
Yes.
Certain disclosure in the report.
Yes.
And paragraph 11.
Authority.
In that case, the authority can revisit the issue of termination, and if the petitioners are interested to proceed with the work, the authority can direct the petitioners to conclude the work in a time-bound manner.
Right.
But this is
anything.
This is absent in the report.
And no communication to you regarding revisitation of the issue, nothing of the sort.
This was the work order was issued in 21, 22 the drawing was prepared, remaining silent that in 2022 they wanted to reduce the work from a G+7 storied construction to G+2. Admission of certain large scale activities being carried out.
None appears on behalf of the state. Stop. The report which was directed to be filed, though not filed before the court, but copy of the same has been served upon the learned advocate representing the petitioners. Stop. The petitioners intend to file an exception to the same. Stop. Let exception be prepared and vacation. 19th? Release the matter on 26th.
Same position if it's your lordship.
Still urgency remains?
Yes, not it's the state's urgency rather. It's a flagship project for the 2026 event.
Very well, let it remain. But communicate this order. Let this order be communicated. to the learned advocate representing the state respondents.
My application.
Yes, please. All right.
That I needn't be troubled with the papers right now, and I'll just indicate. The tender is awarded in my favor. When I apply for the tender, I write to them that I can supply the goods in a certain schedule. The tender
schedule means
in a certain way over a certain period of
time. The time
certain
schedule.
Tranches, yes. The tender also provides that on the issuance of a purchase order, if I'm unhappy with the schedule, then I can reach out to the respondent myself. So because I had participated in the tender indicating that I'll be able to supply an ABCD schedule in that way, I reach out to them. They give a modification advice. That modification advice is again contrary to what I had told them earlier. So again I write. Again they modify. This modification they say now in supersession naturally of the first one. This is again in departure. Then I write to them again. Then they resuscitate the first one out of sheer anger or something. I don't know what happened. Then they resuscitate the first one. These three modification advices, we filed an application challenging, saying this is the tender term because I participate in the tender.
Yes,
saying
yes. Then what
ABC.
happened?
After I file the writ, I serve a notice. Respondent issues a termination advice and recovery advice from me.
Recovery of the earnest money.
Recovery of this
security
that I don't know. Lordship will kindly have a look at these two documents. I did not.
1 minute. All right.
I'll just forward this. I just
period is over.
Yes, Lord. 29 July contract period is over. And he has failed to supply the materials.
No, the document doesn't say so. The document, yes, no, that is the kindly have a look at 4th August. The it is acme. Don't do it parallelly, please. The matter is filed on 27th of July. It's running in the list. Notice is served.
Yes.
4th August, they write a letter. This office purchase order referred above is hereby cancelled with immediate effect for the items and quantities mentioned below. Kindly have a look at reason for cancellation, failed to supply, penalty imposed, recovery of general damages of 34,74,000. Please have a look at the remarks, Manoj. So and so is requested to deduct 34,70,000 odd from the firm's outstanding bill or bills as general damages.
Do you have any outstanding?
With them, yes, Manoj.
Are you a regular supplier?
I'm an approved vendor. I supply to them
on regular basis.
On regular basis. Now they're going to recover based on this. 2 points I want to assail this. One, primarily, when the matter is before the court and the modification advice requiring supplies under challenge, this is an attempt to overreach the court. Your lordships have always held this kind of conduct.
Show me the purchase order or whatever contract.
Kindly have a look at page 43. I'll show that clause, Milord.
The time period within which you were supposed to supply?
29 July.
Where from do I get that?
Page 43, kindly have a look at the purchase order.
Yes.
The contract tender terms are that one.
The bottom line.
Are apni kore din
43.
Kore din?
Yes, please.
Page 43. Commence.
29th March.
29th March 2025. Complete on 29th April 2025. Then again 29th March, this is 1,60,000, 1,60,000, 1,60,000, 1,60,000. Each different tranche. All of them I have to start commencing from 29th of March 2025.
The very next day the purchase order is
That's
given.
right. No, that's the point. So the very next day, Lordship will just have a look at one clause of the tender. If I'm unhappy, I'm reach to them.
What is the material that you supply?
The material that I'm supplying,
Manufacturing supply elastic rail clip.
The description your lordship will find at page 43. So what happens, my lord? Now I have to, rights is the agency. So I have to get this from approved vendors. Rights certifies it. Then I have to manufacture it in a certain way. They've changed the basis on which I manufacture. Earlier I could run my factory for 24 hours. Now they've issued a notification where it can run only a certain period of time. When one rights inspecting officer is going to be there, I'll run it for 8 hours. Within 8 hours in a day, I'll have to churn out the inspection when happen, it will go. So on the next day, 28th, this has been given. 29th, I have to start commencing production. Your Lordship will just have a look at the other two, my lord, what they have done. This I write to them, my lord, the purchase order, your Lordship will find. My lord, kindly have a look at page 44.
Listen, this was there possibly in the tender document
Tender
that
documents, my lord,
you
when I
were
participate,
supposed to supply these articles. You were aware.
what I had to supply.
What
But
you had to supply.
I specific offer that I give is I will be able to supply over this much period of time, which is why they include this clause as page 44, clause number 16. Kindly have a look at.
Yes.
Look, request for amendment of those purchase orders that are available in IREPS module under contract should be submitted through IREPS only. If any condition or clause in this contract is not as per the offer of the firm, the same should be represented within 7 working days, failing which it will be deemed unconditional acceptance of the supplier. So this is one situation where even after the purchase order is issued, I can go and renegotiate the terms of supply. I write to them, then the next one comes, Vinod. Kindly have a look at page 75.
Did you not supply anything?
Yes. No, I could not. Vinod, because they changed it again. Kindly have a look at page 75. Kindly have a look at page 75 once.
Yes.
This is 16th May.
Yes.
Subject, kindly have a look at amendment number so and so. Same purchase order. Recommend following amendments are hereby issued with immediate effect. Now what happens? 29th April. So I write to them. They sit on it. On 16th May, they issue an amendment making it from 29th April. And please have a look at the last entry, last end period is 29th August. But just because I filed the writ petition, on 4th of August, they terminated it.
No, you could not have finished supplying within the last
have
date.
even started. I'll tell you, Lordship, why. Because again, what I write to them, because it's incomprehensible that in May, they write to me saying it started from 29th April.
You cannot expect the authority, it's the railways, to wait for the article because they require this article on regular basis.
Absolutely right. It is just the way that the railways has proceeded. Manoj, I am ready to supply it in the way that I had made my offer. Railway changes that offer. Manoj, this is like changing the rules of the game after the game has begun. I participate in the tender indicating that this is how I will be able to supply. So first the issue on the very next day. So I write to them saying what you've done is contrary to my own offer. Then they amended at page 75. They issue something on 16th of May. Commencement is taken to me from 29th April. If the railway understands that to supply the first tranche, I need 29th April to 16 July. Then taking away 2 months, 2 weeks is crucial to me. Then I again write. Your Lordship will have a look at the next one now.
No, but then what can be done now?
My only request is, since this termination has come, my interim prayer today, I will have to challenge this either by way of a supplementary in this or maybe separately, and BCJ Lordship will take this up together. This kind of recovery after the matter is there, I have a specific prayer restraining them from taking any coercive measure. But the recovery, Your Lordship, will stall because the railway does not have any jurisdiction to recover from my outstanding bills. They will also have to take recourse to law. And this is, it's palpable, my lord. 27th of July, how are the High Court judgment? 27th of July, I filed the writ. The writ is running in the list. The moment service is made of all these time, from April, they don't do anything. From March, I'm sorry. Just to obviate any kind of answer or issue that they may face here, they terminate and seek a recovery. If the recovery is made, then the entire thing becomes academic.
This writ petition has become infructuous by virtue of this
that is what I'll,
cancellation.
That is what I'll only beseech your Lordship. Not kindly have a look at this one judgment. There's a coordinate bench, slightly different circumstances where a section 14 order was under challenge. The application was filed. It was pending.
Section 14 surfacing.
It was pending consideration. While it was pending consideration, the authorities went ahead to execute that order. So court said that this much deference you have to give to a constitutional court. Because if it's before a court and without actually adverting to the merits, you try and what has fallen from your lordship today is the basis on, is the reason why they've issued the 4th August notice. That it becomes infructuous, I have to come and file. It technically may not become infructuous because I have prayers to say that no coercive measure will be taken. And this is, if failure to supply is a ground, then this cause of action is part of the ground for rejection. It is true that I might have to challenge this separately. But pending this, I'm bringing it to your lordship notice, kindly restrain them from taking any coercive measure. I have that specific prayer in my writ petition. Otherwise, page 26, your lordship will see my prayer is there not to take any coercive measure. Otherwise, they don't wait to come to court. They know we are mentioning the matter. Notice of mentioning is served. They come and straight away terminate it. And the ground is failed to supply. Kindly restrain them from making any recovery and keeps it next week. I'll come with both.
The petitioner participated in a tender process and being successful, a purchase order was issued in its favor by the Southeastern Railway on 28th March 2025. Stop. There was a scope. Now there is a delivery schedule mentioned in the purchase order. Stop. The purchase order also mentions that requests for amendment may be submitted if any condition/clause in the document is not as per the offer of the firm. Stop. The petitioner submitted the request and repeated communications by and between the parties continued for some time. Stop. The petitioner filed the instant writ petition on 25th July 2025, apprehending that the authority may take coercive step as the date for delivery of the articles expired in the meantime.
Was about to expire.
Some of the articles expired in the meantime. Stop. During the pendency of the instant writ petition, a cancellation advice dated 4th August 2025 has been issued. Stop. The petitioner is aggrieved by the same. Stop. Paragraph. Prayer has been made to permit the petitioner to come up with a subsequent application. And in the meantime, restrain the authority from taking any coercive step against the petitioner. Stop. Paragraph. Leave is granted to the petitioner to file an interlocutory application bringing the subsequent fact on record along with the prayers. Stop. The writ petition stands adjourned till 27th August, until 20th August, 20. Stop. Next. The respondents are restrained from taking any steps for recovery of the general damages as indicated in the cancellation advice dated 4th August 2025 till 29th August 2025 or until further order, whichever is earlier.
Very good.
Yes, it is a different issue. Let them come up with an application. Restraint order only regarding recovery. You will services taken or recovery will take some steps.
Right now, this matter has become infractuous. So
Yes, yes.
By issuing that notice, you should come to court.
Right.
So the contract will not over.
Next.
Great.
Well, Fraud, fraud, fraud. Fraud on it.
The petitioner.
Madam, for the state.
The petitioners were granted patta with regard to 2 decimals of Bastu land by the state. And my lord, my name has also been incorporated in the record of rights. Page 12 is the grant of patta in our favor by the state. And page 15 is the record of rights.
What is your prayer?
My lord, what is happening since 11th July 2025, the contractors of the Chief Medical Officer Health and the Block Medical Officer Health, they are encroaching upon my land, digging up the soil in order to create a primary health center.
All right.
My
Yes.
lord, respondent number 5, my lord, Chief Medical Officer for Health, my lord, has not identified that said land, my lord, because my lord, land
Has not identified means construction is going on or not?
Digging up the
construction is, my lord, actually going on, my lord.
Going
They are
on?
instructed, my lord, because 4th August, my lord, say they are received the bid, my
Yes.
lord. That's why
Is any construction going on or not? This much the
yes, my
for
lord, construction is going
going on over which plot of land?
not their land, my
All right. On which plot of land?
lord. Plot of land is
Plot number is
one-
mentioned?
1202 number.
1202. What is the plot number of the petitioner? It's
Well, that is my
1202 is his plot.
That is my plot.
My lord, they are, my lord, give me some time, my lord, for 2 instruction, my lord.
But in the meantime, if you say that the construction is going on over 1202, then you have to stop. You have to restrain yourself.
Annual
Record of rights 1202. Which page have you annexed?
my lord, record of page 15.
1202 page 16 is there. Bastu Ongshu is
Page 15 is a
00.12. Ongshu Puriman is 0.20.
Kindly see
There,
at the
it
bottom.
must be 1202 is a big plot of land.
Kindly see at the bottom. My lord, 1202. Page 15, bottom.
Yes.
And it is in the name of me and my husband.
No, no, it's a big plot of land. Which is it demarcated? Your portion, is it demarcated?
Demarcated portion.
Your portion is demarcated.
Portion. At the time of grant of patta. Page 12, 13, 14. And my lord, pursuant to filing of this writ application, I have come across this document. Kindly sees.
Let me
This is a communication to the PMOH by the CMOH.
Yes.
Saying that we are aware of this complaint representation. See to it.
Please come. The petitioner alleges that the Chief Medical Officer of Health, South 24 Parganas, is taking steps for construction of a primary health center over the Rayati plot of land of the petitioners. Stop. The petitioners have annexed the copy of the record of rights to suggest that plot number 1012 that certain area of plot number 1202 is recorded in favor of the petitioners. Stop. Patta was also granted in their favor by the
Governor.
State. Stop. Next. Learned advocate representing the state respondents seeks time to take instruction in the matter. Should I? There is a representation. Let it be forwarded and let them consider.
Till that time, my lord, they should refrain from digging up my land and proceeding with the construction. I'm not standing in the way. Let them consider my representation.
Total land
But
is
that,
seven,
that they, this
16.43
illegal
acres, my lord, and the
digging up should
petitioner's
stop.
land in
And
7.50 acre.
I have already my foundation of ground
Answer.
floor.
The petitioners assert that the portion belonging to the petitioners is clearly demarcated. Stop paragraph. On a perusal of the record of rights, it appears that the entire plot 1202 does not belong to the petitioner. Stop. Only a portion of the same, comma, which the petitioner claims to have been demarcated, comma, belongs to them. Stop. An objection from the end of the petitioner is pending consideration before the Chief Medical Officer of Health. Stop. The petitioner has brought to the notice of the court that the Chief Medical Officer of Health, by a communicating memo being number CMOH within bracket SPG/5685, dated 25th July 2025, has requested the Block Medical Officer of Health to investigate into the matter. Stop paragraph. As the objection filed by the petitioner is pending consideration at the end of the CMOH, accordingly, the instant writ petition is disposed of by directing the CMOH to look into the matter and ensure that the royalty land of the petitioners are not encroached upon by the state authority. Stop. In the event the state respondents require the land of the petitioners for any public purpose, comma, then steps may be taken for acquisition of the same strictly in accordance with law. Stop. The aforesaid respondent is directed to grant an opportunity of hearing to the petitioner prior to taking a final decision on the objection filed by the petitioner. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If in the meantime any construction is made over the land of the petitioners, comma, then the CMOH shall then the said construction shall abide by the decision to be taken by the CMOH in this regard.
CMOH not CMOH not constructed by my lord petitioner's land, my lord.
No.
No, my
Very well. If it is not,
because my lord, total land is my lord 16.43 area acres and
what?
Item number appearing for the petitioner, Shoma Majumdar was appearing in this matter. Item number 2.
Yes.
They were not report.
It has been recorded that you were not there. It has been recorded. Yes, next.
Lordship, item number 5, Lordship. Lordship, I need to leave for. I want to add as a party, necessary party, Lordship, in this petition, in this writ petition, Lordship.
Yes, my lord. That I will not stand in the way. May I just?
Lordship, why I am saying, Lordship? Otherwise, Lordship, one writ petition is pending, Lordship. Otherwise, Lordship, decisions will be unjust. Lordship, I am the complainant against him, Lordship. Already one case or one writ petition is pending, Lordship, in this bench, Lordship.
Let him make an addition of. May I just place it, my lord? I have a very small case. Kindly comes to the grievance is that before expiry of the term of my lord the pharmacy council, my lord again I have been, my lord, the another term has been, my lord, given by the impugned. Kindly comes to section 19, page 26 of the Pharmacy Act. I will be placing 2 sections. Thereafter, I will be going to the, my lord, impugned communication. Constitution of the Commission of the State, my lord, is at page 26. Except where joint state council is constituted in accordance with an arrangement made under such and such, the state government shall constitute a state council consisting of the following members, namely A, 6 members elected from amongst themselves by the registered pharmacists of the state. I am not this. I am not
A
amongst these.
pharmacist. You are not a registered pharmacist.
I am a registered pharmacist, but I am not an elected person.
All
B,
right.
5 members from whom at least 3 shall be persons possessing a prescribed degree or diploma in the pharmacy or pharmaceutical chemistry, or 5 and registered pharmacists nominated by the state. I am this. I was nominated by the state government. 1 member elected from amongst themselves by the members of the medical council or the council of the medical registration of the state. This is, my lord, the medical council. Chief administrative medical officer of the state. This is DHS. And DD is officer in charge of the drug control. Now, my lord, I was, now kindly comes to next page, next, 29, page 29. Section 25.
Yes.
Terms of office and casual vacancies. Subject to the provisions of this section, a nominated or elected member other than nominated president shall hold office for a term of 5 years from the date of his nomination or election, or until his successor has been duly nominated or elected, whichever is longer. Now, 3 is nominated or elected member. No, whichever is longer. Now, my lord, kindly comes to my nomination. First nomination was in 2012. I will not trouble your lordship with that. Kindly comes to page 43. Page 43. On expiry of the term of lordship, is that page?
Yes, yes.
On expiry of the term of West Bengal State Pharmacy Council on 18/6/2018, Governor is pleased to reconstitute the council in pursuance with Act 19B, C, DD and E of the Pharmacy Act by nominating following officials. My name is at serial number 2. From 1 to 5 is section 19B. C is the Director of Health Service under section 19D. Drug controllers 19DD. So therefore, and last is, my lord, 19C. So from 2021, 5 years would be 26. Now, my lord, kindly comes to the impugned letter, page 53. The letter itself, my lord, proceeds on a misconceived notion. This, as of today, has not been, my lord, published in the Gazette. On expiry of the term of the West Bengal State Pharmacy Council, the governor is pleased to reconstitute the council in pursuant to section 19B, C, DD and C of the Pharmacy Act by nominating following officials. My name is not there. And, my lord, there are other mistakes also that has glaring, my lord, error apparent on the face of the record. 19C, they have given the name of Director of Health Service. It should not be 19C. 19C would be, my lord, the elected members of the West Bengal Medical Council, and, my lord, 19D some others. Now, I am concerned with regard to the fact that this particular thing has been done prior to expiry of the term. Next page is the nomination of the elected members. 19A. This is different. This is not with regard to, this has been done pursuant to orders of this court. The elections was not being held for quite long time. So therefore, this is, my lord, this has been done. I am not covered in this. This is not my. So therefore, I have annexed this only to show that, so that it doesn't come from the other side. My contention is very, my lord, limited. Now, my lord, kindly sees there was a page 48. There was a vacancy. The president who was elected amongst ourselves, Dr. Rabindra Devnath, had expired. Page 48. For filling up this particular vacancy, the registrar had been making communications, and there was a reminder letter. And, my lord, a particular gentleman.
No, tell me
Mr.
one thing.
Yes.
Your name is not there. And is this the reason you filed the writ petition?
I am challenging page 53. In view of the fact that prior to expiry of the, my lord, term of the council, in total deviation of section 25, my lord, page 53 has been issued, and this proceeds on the basis that the term has expired, which is not. Because from 2021, the term is supposed to expire in 2026 February.
Lordship, one
This is
read.
limited. This is my limited prayer. So this
Yes.
could not have been issued.
Yes.
Other points, if they
Lordship, already one.
I don't know who he is appearing for.
Lordship, I am the pharmacist. I am the one of the candidate of this election. I make
Election. Where is the
no,
election?
no, Lordship, I am telling Lordship. Lordship, I am telling Lordship. I made complaint against him before the state authority, pharmacy council, regarding how he misused his power as a
Alright.
government employee.
Alright.
This writ petition is pending already.
Alright.
Already.
Order was passed by the court.
Passed and
Appeal
stated
preferred.
that filed the affidavit
Alright.
and already stated that the result of this my writ petition shall abide for all the activities of the state authority, Lordship. I am serving the.
No, it's all right. Then what has happened?
Lordship, my prayer is that in that writ petition, he should be removed from his post. Why?
Right.
All the
But this is
stated
not
in the writ petition.
removal.
Already.
It's the reconstitution of the.
All definitely.
Maybe
Lordship,
that-
I want to. I want.
Understand what his problem is.
Yes, Lordship, I'm telling you, if I not added in as a party,
Yes.
and my writ petition, if not hearing along with this,
Yes.
there will be a highly chance of unjust. There is a highly probability to divide the judicial mind, Lordship.
All right.
There is a high chance of multiple legal suits.
All right.
Lordship. So that's why I am.
So you want your matter to be heard along with this. All right, I get it. I get it. Yes.
My lord, prima facie, though I have not today instruction because yesterday, my lord, I have received the brief, but I have gone through. My lord, two documents under my lord, the annexures are important. So far, they are the issue presently, my lord, raised. It appears from page 43 that the last, my lord, the council was, my lord, constituted on 22nd February 2021, as it appears from page 43. Now, according to the, my lord, the statute, that the 5 years, my lord, the tenure, and it appears that 5 years and whichever is longer also expiration. And there is, I have not seen that there should be any retrospective of revert back, because earlier, my lord, the council, my lord, this stood expired its duration in 2018. After 2018, 2021, this council was constituted.
So from 18 to 21, what happened?
Now, I think that the earlier, my lord, they continued possibly. But normally, sometimes, my lord, there are statutes where I have seen there is a provision regarding revert back. Provision regarding revert back. But here I have not seen that the effect should be on and from the date of last expiry of the last council. I have not seen, my lord, though I have no, my lord, instruction. If, my lord, if it prima facie appears that from 22nd February 2021,
for
then,
5
my lord,
years.
5 years should be, my lord, some more months are to be left.
Yes.
So, my lord, I leave it to your lordship. My lord, may I tell, it is better, lordship, that, my lord, may I file a very short report in the form of affidavit before your lordship, and my lord kindly take it on the next day. Because what I say, that is on the
But
basis.
one thing that is troubling, page 53,
Page 53.
the date at the top is 28th of July, 25. But
Yes.
from which date it will be effective, it is not mentioned anywhere. It
Whether,
starts on expiry of the term, please to reconstitute. There is nothing
First
to
of all,
say
my lord,
when it expired.
all the writ petitioners, this contention, they are, my lord, very much they are on this, that the expression on expiry of that.
Where is the date of expiry? Where, when, from will this become effective? Nothing is
It
mentioned.
is also, my lord, troubling me because, my lord, without, I have tried my level best, but my lord, my lord, could not, my lord.
Who are you, please?
Pharmacy council, my lord.
Lord, state is primarily the answering respondent, but only one issue I want to make, my lord, this writ petition which he is talking about has nothing to do with this.
Yes.
Whoever state sends us, we will function with them.
All right, you do not bother about his writ petition. What you have got to say in this writ petition?
This writ petition, my lord, these members are nominated members. We have no control over them. Whoever
Right.
states thinks fit, whoever states give, we will work with them.
All right, and just from the date of nomination or election until his successor has been nominated. This nomination be done in the midterm.
Yes.
This has to be seen.
Maybe this is, my lord,
This-
doctrine of pleasure would come into play.
Yes, maybe doctrine of pleasure, right? Because this is nomination.
Nomination.
And until his successor has been nominated, can the nomination be made in the midterm? But the expression used is on the expiry of the council. So these are contrary. These are contradictory. Mr. Sen will take instruction. Please come.
I'll be praying for stay of operation, my lord, because yesterday they had tried to form a board. I have been informed that that meeting has been postponed.
The petitioner claims to be one of the members of the West Bengal State Pharmacy Council, which was reconstituted on 22nd February 2021. Stop. According to the Pharmacy Act, 1948, the State Council is to remain effective for a period of 5 years from the date of its nomination. No. According to the act, a nominated, not council, a nominated or elected member other than the nominated president holds office for a term of 5 years from the date of his nomination or until his successor has been duly nominated, whichever is longer. Stop. Submission of the petitioner is that 5 years term from the last date of constitution of the council is not yet over. Stop. The reconstitution has been made by removing the petitioner from the
entire board.
the entire,
Yes,
everybody has gone.
I think because it's a reconstitution.
No, maybe some members are still there.
Maybe some.
Yes.
But it's a reconstitution.
কি বললাম?
Reconstitution has been made.
আচ্ছা ঠিক আছে, reconstitution has been made during the validity period of the council. Step paragraph. To answer the issue that has been raised before the court, instruction from the state respondents are required. Stop. Learned advocate representing the state respondents is directed to file a report disclosing all facts and figures. Stop. Such report shall be prepared and circulated by 29th August. Stop. It will be open for the petitioner to file an exception to the same by 12th September. Release the matter on 22nd of September. Stop. Let this writ petition appear along with, give you the writ petition number.
WPA number 7563 of 2025.
Name of the parties.
Shimanta Bhattacharjee versus the West Bengal Pharmacy Council and others.
I'll stay of operation of this, my lord. I'll be
All right.
No, no, Lordship. The point number 2 of this writ petition is very much relevant with my.
I'll pray for staying of the operation of this one.
As the constitution, as the reconstitution,
Not to give any
further
further effect.
Acha. As the reconstitution of the council is in question in the instant writ petition, comma, the authority is directed not to give any effect and or further effect to the reconstitution until further order of court.
Same as per my detailed function, because my lord, my elected members have come in. I have to constitute a board in accordance with law. Because we
will be there.
The existing board will
Yes,
function.
Existing board will be there.
existing board can function, but we have got new members who have elected. We have to give that effect.
How can the election take place?
But because now we have to elect a president. Now, if if we give this notification into effect, then we will call these new members into the meeting of conducting election of the president. But if this is stayed, then we have to call the previous members.
Previous
So if
members.
the
That is the previous.
president. Then if this restriction succeeds, then we have to again call them. So this is the situation. That is why I'm.
Tell me one thing, if I can faintly remember, was this the matter where the Honorable Chief Justice had to intervene?
Yes, Lordship. Of 19A.
Chief Justice directed to conclude the election.
Yes.
Explained that.
Do one thing. In that case, reduce the time period. আজকে 7 তারিখ তো you come up with this
instruction. Lordship, kindly
next week 14th এর ভেতরে করে দিন তো list the matter on 20th of August 20 and the interim order is till 29th of August. Interim order is till 29th of August.
Well, this report, my lord, lordship, not
Not an affidavit.
And my lord, I'll be
Circulate
praying.
it.
I'll be praying for adding the National Pharmacy Council as a part.
Why?
20th.
My lord, they are
Will it be
the.
required?
My
Will
lord,
it be required?
Yes, my lord.
At
Because
this stage, why? Where
I have-
is the national
why I am
authority
saying
coming?
so, why I am saying so? I am also a member there.
Maybe.
Now, my lord, if this is my lord, if they proceed on the basis of this impugned communication, then my nomination there will also be cancelled. That will be a cascading effect. I am also a member, so I'll
Is your membership coextensive with your membership over there?
yes, 3H. It is. This co-terminus, I.
All right.
I'll be adding them as part.
All right, leave
One
to add.
member from the. Yes.
On the prayer of the learned advocate representing the petitioner, leave is granted to add the National Pharmacy Council as party respondent in the instant writ petition. Stop. Let a copy of the writ petition be served upon the added respondent.
should kindly give the liberty to me also to add it in this
No,
writ
no,
petition
it's
also.
application for addition of party
You, in
unrelated
the
matter.
meantime, you come up with an application as to how you are
Prejudice.
required to be heard in the instant writ petition. Your matter is separate.
Definitely.
That is there.
His matter is with regard to my election where I am one of the returning officers. His grievance is against me.
Next.
Deeply obliged. Observe.
Number 6.
My application.
No, this. The affidavit of service, Manoj.
What is there on the other side?
That we've served by email, by hand service, they've refused. There's an
Northeast
extreme
Frontier Railway is a
principle, which
difficult
is why we had mentioned it day before. Your Lordship, be pleased to keep it today. Now, I'll just briefly tell your Lordship, I'm in urgent requirement even for an ex parte identity, my lord. We played for dispensation of Rule 26. I'll tell your Lordship why. My lord, there is a rail track that is being laid, that was being laid from Bangladesh to Agartala. I am the subcontractor whose designs for laying this rail track.
Yes.
Whose designs for laying this rail track
Hmm.
for the Bangladesh side is complete. For the Indian side, it's approved by the RDSO.
Hmm.
IRCON is the project implementation agency. So every design drawing that we submit goes through IRCON, goes to RDSO, RDSO applies.
Hmm.
Lord, with regard to my part of the tender, after this, they issue a single tender only for me because it's a PAC item, which is a proprietary item of my design and drawing, which is being used to connect these rail tracks. Lord, I am suddenly informed that this particular tender is discharged. My security deposit is returned to me. and it's showing also as discharge. So I take the security deposit back. 22nd of July, and we specifically pleaded it. I get a call saying, please explain to us how to fit this particular dual type product that we manufacture in laying of this railway track. Well, then we unearthed, I'll just show one document. I don't think I'll have to argue this matter any further. They floated a new tender of a product type which I don't manufacture using my designs that I have given to them. And somehow in the tender document, it's mentioned that this is a proprietary design and drawing of the petitioner. Just have a look at that, Milord. Please have a look at page. Kindly have a look at page 320. $321. 321, your lordship will kindly have a look at. No?
Were you showing something from 320?
321.
One. Yes.
Kindly have a look at the bottom, Milord.
Yes. Manufacturer.
Kindly see designed by 301. Milord, oh, I'm sorry, Milord. Your lordship, I'm showing looking at 301. 321, kindly have a look at. Yes.
Manufacturer.
At the bottom right hand corner, Milord, this is the design that has now they've given with the tender. I'll show that. This is the impugned tender. At the bottom, Milord, manufacturer. The petitioner's name, Rahi Technology. Milord, Rahi Track Technologies Private Limited, Kolkata, India. There's a line, and then your lordship will see this drawing is the proprietary of Rahi Track Technologies Private Limited, NH so and so Jadavpur, and shall not be used, copied, and reproduced in any part or whole without prior consent in writing. And then the manufacturer, my number is there. Well, this was there in the first tender that had given. Now the impugned tender, they have put this, but they've disclosed mine. I'll show Milord how this design forms a part of the offending tender. Well, it starts at 310. The impugned tender. Kindly have a look at 320. Serial number 7. Documents attached with tender. Please have a look at serial number 5.
Drawing.
5361670. Drawing.
Yes.
So now that admittedly 321 is a part of this impugned document, impugned tender.
Yes.
Admittedly, this drawing is my proprietary drawing.
Yes.
Now this has been made a part of this tender for a different manufactured product where you're using it without my consent in writing. So what happens is, and now Milord, he's right. At 310, if your lordship looks at once, this is the tender that we've assailed. Kindly have a look at the tender type. It is open. So whoever is manufacturing this product type, which I don't manufacture, will use my drawings. Now it's put out in the public at large as a part of the tender document. It's an open type tender. The railways themselves admit it can't be used because this is the drawing that I had given in respect of the first.
And the railway is not taking this material from you.
No, I don't manufacture this. Well, the other prayer in my writ petition is that this kind of tender that you floated, it must include my product type also. Because I also manufacture this kind of product type, and international practice, I'll show books, Milord, that for international practice, you will have to use these two types of product. Now, what they do...
But then why all these things in a writ petition?
Well, I have no other remedy.
What you do not have any remedy?
It is gone under the tender they're using. This is not an intellectual property issue. Your lordship has seen page 321.
A suit can always be maintainable. You can a suit, you can file a suit, you can get an order of injunction restraining them.
Here, what is happening is this is ex facie in violation of my right under Article 19, 1G and 14. The railways themselves requires that it can't be used. And I am showing 321 from the impugned tender. considers this, my lord, I am not allowed to participate in the tender process.
And the tender document is at page 310?
310.
And
It's
it is dated 25th of June, the closing date. Today we are in August.
I don't have
You
any
want an interim order today?
Nothing has happened, my lord.
Nothing has
Commercial
happened.
bid has also not opened.
You get hold of the learned advocate for your other side.
My lord, similar in the other matter, my lord, kindly stays them from using this drawing.
No, this is, you say this is an international project.
No,
is
my lord, this is
involved
not an international
something.
project. No, this tender, I had participated in that. And I had given this drawing for that. That tender stands gone. It's gone. That tender is gone. The security deposit refunded. The drawing that I had given in respect of that, they are admitted in this page 321 that this is my drawing. It can't be used without my consent in writing.
Yes.
And now they floated another tender using this drawing. Well, this is expressly hit by Article 14. My entire design, this is my business. My wherewithal, my technical know-how, my entire business is to prepare this design so I can use these products. It was the railway's way to extract this design from me and give it to someone else to use it. 321 is an admitted position. I'm showing their document. Railway chooses not to appear today. But at least I'll bring them.
You give one notice and come back. None appears on behalf of the respondents.
I'll serve them again by hand. Lordship will provide that I will serve them again by hand. Second. Kindly, in the meantime, Lord, with 321, there can be no defense. At the bottom where they say that it can't be used without my consent, this drawing can't become a part of another tender in which I can't participate. In the meantime, please restrain them from using this drawing.
But then why cannot you participate?
This is a different product type.
You do not.
I don't manufacture
it.
Well, this was the whole. So we've pleaded. This is actually to give it to one particular favored candidate. So they float one tender, take my design, which is a proprietary concern.
No, I get it. But then you do not manufacture this article.
Yes, but
you
my
are not participating in this design. So no interim order.
No, may I just indicate this?
None
Kindly bear with me for 1 minute. The fact that my doors are closed.
Let further notice be served. Release next Wednesday. Come back. Let's
In the meantime, they'll issue the notice.
Which notice?
In the meantime, let them not finalize the tender. This much your lordship
How will you be concerned if this is finalized?
This drawing will be utilized by somebody who comes in. Today, I am showing to your lordship page
This
321.
drawing is of a product.
No, that's what I'm saying. It's of a design. That kindly comes back to 321. No, it's my mistake. I could not explain this. Kindly have a look at 321 once. I'll explain this. Just for 30 seconds, have a look at 321.
Yes, 321.
321 at the top, your lordship will see the entire railway track is there.
Yes.
And in the bottom, your lordship will see is designed to scale. So 101255 mm thick web, lead, heat treating curved, then again heat treating welded curved. So I have laid out the entire design as to how this track can be laid for this to actually work. Because it is my technical know-how that I've used and given them the design, they write here that this drawing is the proprietary of the petitioner and cannot
doesn't matter.
be used.
It can be taken care of on the next day also.
No, then
come back on the next day.
Not 1 week, your lordship will stay them from utilizing this. If it happens.
If you can come earlier, I do not have an issue.
I'll come on
Today is
Friday.
the 7th. Friday is tomorrow?
Tomorrow, I come. Monday I'll come.
Tomorrow.
Monday I'll come.
Tuesday you come. 12th. Make it 12th.
Lord, could I just pray for one thing? Lord, we seriously apprehend that this drawing is going to be utilized. If it
maybe it has been utilized in the meantime.
Tender has not been finalized.
Yes.
Has not been.
Any steps taken shall abide by the result of the writ petition. Come back. Next.
Item number 7, my lord, I am for the petitioner, my lord. May I?
Or in the meantime, if you can get hold of anybody who appears for the railways, then also I can. No, not tomorrow. Today. If today it is possible, you still have 20-25 minutes left. If you can get somebody.
They've refused service by hand, will not be served by.
Northeast Railway. I know if this is a difficulty. I was looking for somebody from the railways. Nobody is here now. Cannot help you. Come back then in the next day. Yes.
My lord, I am for the petitioner, my lord.
Yes, please.
Lord, may I request, my lord, can it be heard in camera proceedings?
Yes, yes, why not?
Because some issues.
In camera means you want the live streaming to be off, or it just only the court and the parties?
Court and parties.
In that case, yes, you have to wait at least till the court rises.
I'll rather.
Please wait. Pass over for the time being. Just wait. Yes.
Is that appear on behalf of the respondent bank in this matter?
Now, will kindly turn to the impugned sale notice at page 159.
Yes, please.
Now, at the next page, 160, but can notice this is pursuant to section 13(4).
Is your name there in page 159? Saiful Malik, right side box.
Yes, yes.
Saiful Malik.
159,
159, right side box.
Saiful Malik.
All right.
No, but I am on the issue, Mullah, this is pursuant to Mullah, section 13(4).
All right.
Notice. Now, when the statute has given me that alternative remedy, I have already filed an application in the section 17 challenging 13(4) proceedings.
Yes.
Keeping that pending, now they want to sell the property. How can they make everything?
But then why not before the tribunal and why over here?
Because now the sale notice is not issued by them. They
It can be filed by way of an interlocutory application.
My application in section 17 is pending for a few months. This is the way
This
tribunal
is
moves.
the difficulty. Every day matters are mentioned, matters are pending before the tribunal, not taken up. And
let them not proceed with the sale. Let the section 17(4), which was filed on 26th of March 2024, it's still kept pending. And now they take advantage of keeping that pending.
Yes.
How can they make the statute infructuous?
My first aspect was submitted regarding the maintainability of the writ petition because admittedly they have already before the tribunal.
Yes.
My second submission before your lordship would be not only one section 17 application, they have made an attempt to stale the entire surfacey proceedings by filing two separate section 17 applications.
By two applicants?
By the same surfacey application.
Same party.
In both the surfacey application, they failed to get any interim order on merits. Lordship, kindly see the orders. First is TSA 4 of 2024. The entire order of annex, no interim order. Another surfacey application which was lastly taken
Suppose after hearing the securitization application of the petitioner is allowed. What will be the fate of the sale?
That's the fate of the sale. The section under the Surfacey Act.
Yes.
The tribunal is very much empowered to set aside even the confirmed sale.
Yes.
But in order to get a interim protection, they have to make a prima facie case, which they ought to have filed an application before the tribunal.
Yes, yes, that they will.
That's kindly see 138. This is lastly taken up for hearing on 7th of July. Then no application. You'll also kindly see the application. Auction notice. Kindly see the auction notice. The date of
is
auction
dated
notice.
21st of June 25.
Yes, in the month of July.
Why
they have not placed any interim application for stay this. Why before this court? Because they have no prima facie case. Kindly see the second surfacey application. The petitioner cannot be allowed to
same cause of action, two surfacey applications.
Same surfacey proceedings. Let's see, kindly see the last order passed in SA 138 2024, 7th of February 2025.
7th of February?
7th of July. Last page. The last page.
7th July.
Let's see, the surfacey applicant has filed assay number such and such, challenging the action of the bank, interim period being IA number such as challenging the action of the respondent for taking possession of the property as per the order of the CGM, which is in contravention of the order as the same has to be executed within 15 days, but this court has been compelled after 15 days and the bank has taken possession of the property. Landed advocate of the respondent bank has challenged the maintainability of the assay and IA, that is such and such.
But that has to be disposed of.
Not disposed of. Tribunal declined to pass any interim order. There is also issue of maintainability spending. They are unable to get interim order on merits.
28th of July 25.
Yes,
what
again, on that
happened?
particular day did not.
So many dates are there. You do not bring this to the notice of the
Only
tribunal.
to still the surfacing process. They,
Lord,
before the
if-
writ court.
if, Lord, my alternative remedy under section 17 appeal is
And
pending,
Lordship is
let them
aware.
decide it finally, then you proceed.
The Katina of judgment of the
Why
Honorable
you
Apex
cannot
Court.
create further trouble.
And by the time the application is pending, the bank is not getting anything. The bank has to take steps for recovery of the loan amount.
Which we are proceeding in accordance with law.
What is the secured asset?
The secured asset, the immobile property.
What is the immobile property?
As their pleadings,
Lord,
it
the
is
secured properties, Lord, the building and the company properties. Page?
97.
The date of sale is 7th August. That means today.
Today.
Did you get any buyer?
No.
Bidder, have you received?
Let's say I have instructions from the
11
bank
to 3.
about the some bidders are interested to participate.
That's big.
Nothing more.
But not yet
Nothing
been
more.
finalized.
And in the sale notice, have you mentioned about the encumbrance? You all publish sale notice mentioning free from all encumbrance, and then it is found the surface proceeding is pending. The section 14
Judgment of the
application
Honorable
14.
Apex Court on the point that the mere pendency of an application cannot be an encumbrance.
Very well.
Encumbrance in the nature of if there is some tenants are there or
Yes.
there is an order of sent from any court of law.
Despite having tenants, you mentioned
But
there is
with
no
due respect,
encumbrance.
with due respect, subject to your lordship kind consideration. All these points are kept open for the petitioner in the tribunal.
Right.
Yes,
so I am
yes.
also
They
asking
appeared
that.
on 7th July. They have time on 28th of July.
Hey,
No
please
interim
come.
application. How the writ petition is maintainable and paying for
The
any
petitioner is aggrieved by the steps taken by the bank to recover the loan amount under provisions of the SARFAESI Act by issuing notice of sale dated 21st June 2025. Stop. It has been brought to the notice of the court that the securitization application at the instance of the petitioner is pending consideration before the Debts Recovery Tribunal. Stop. The petitioner has failed to obtain any interim order from the said forum. Stop. Next. The date for sale is fixed today. Stop. Next. The as the bank is proceeding in accordance with the SARFAESI Act, comma, accordingly, the court does not intend to restrain the bank immediately. Stop. Leave is granted to the petitioner to file interlocutory application before the tribunal in the pending securitization application. Stop. In the event such application is filed before the tribunal by, I give you a week's time.
Yes, yes.
Today is 7th. By 14th, comma, the tribunal shall endeavor to take up the matter for consideration within a fortnight thereafter. Stop. The writ petition stands disposed of. Any steps taken by the bank in response to the sale notice shall abide by the order to be passed by the tribunal
Obliged.
in the
Obliged.
securitization application.
Obliged.
Disposed of. Next.
With your lordship. Obliged.
Nine, my lord, I am for the petition.
Yes.
This is the affidavit of service. I have served them on mail and I have also served them by post. And the sale was yesterday.
Bank of Baroda.
My lord.
Mr. Dipanjan Dotto. Is he here? No. What has happened?
We do not know the sale whether sale has been.
Where is the sale notice?
Sale notice, my lord, last annexed at page 21.
Why did you not go before the tribunal?
Yesterday, I have taken leave that the client.
Yesterday?
Yesterday, leave was granted and.
No, leave is all right. Why did you not go before the tribunal? This is 7th July 2025 sale notice. Today is 7th August. 1 month has elapsed. What has happened? You do not know. Please come.
We will. And kindly grant 1 month's time
For what reason?
so that we can approach the DRT.
You need 1 month's time to approach the DRT. Overnight, you can prepare a writ petition. Update yourself. All right. Go before the tribunal. The law says so. Sometime. Yes. The
Whether the
petitioner
sale, my lord,
is aggrieved by the auction notice published by the Bank of Baroda on 7th July 2025 to recover the loan amount by invoking provision of the SARFAESI Act. Stop. According to the provisions of the SARFAESI Act, any person aggrieved by any steps taken by the bank to recover the loan amount may approach the Debts Recovery Tribunal for relief. Stop. Nearly a month has elapsed from the date the sale notice was published. Stop. The petitioner ought to have approached the tribunal for necessary relief. Stop. The bank is not represented today. Stop. The affidavit of service filed in court is taken on record. Stop. The court is not aware as to whether the sale has fructified or not. Stop. Next. In view of the above, the instant writ petition is disposed of by observing that it will be open for the petitioner to challenge the steps taken by the bank to sell the secured asset before the Debts Recovery Tribunal. Disposed. Next.
grateful man.
Yes, I'm state respondent.
But I am for the petition. This is a assignment of the police election. Can you kindly fix a date? Mr. Firoz Edulji is appearing in this matter. Any date in the next week, Wednesday, Thursday.
Is there any private respondent?
Yes, I have served,
No, regarding the assignment, did you serve?
No. It was released by his lordship on 4th.
All right.
So, may I be permitted to serve again?
Yes, otherwise the other side.
It is listed.
Oh, private respondent is the investigating officer of the Air Street Police Station.
Yes.
Then you must be representing.
Yes.
Why is the investigating officer implemented by name? You have any allegation against this officer?
My lord, there is something, my lord. There is some communications that we will place.
Learned advocate for the petitioner seeks accommodation. Stop.
Petitioner.
List next Thursday. Stop.
Malad is fixing on
Next Thursday.
14th, my lord. Deep love,
Yes.
14th, 14 tarikh. Extremely grateful. And on this.
This is my writ petition.
I'm on behalf of the state.
This is a case for non-payment of the admitted dues work done by the petitioner under the Monrega scheme, my lord. Although the bill was prepared and submitted before the authority concerned, my lord, that is annexed P4, my lord, the amount.
Who is for respondent numbers 5 and 6?
Lordship, I'm appearing on behalf of respondent 5 and 6, Lordship.
Yes.
Led by Mr. Shubhankar Chakraborty, Lordship, in this matter. Lordship, on multiple occasions, we have approached the necessary departments for instructions, Lordship. Till date, we haven't received any.
Which department?
Lordship, the Ministry of Rural Department. To the Joint Secretary as well, we have written a mail.
Yes.
If Lordship kindly peruses the trail mail as well. We have on multiple occasions asked for instructions.
You are not getting the instruction.
Lordship, not till date.
Please contact the DSG.
DSG.
Yes. He can connect you up to the higher authorities.
I don't.
Learned advocate representing the Ministry of Rural Development, Government of India, submits that despite repeated efforts, the learned advocate has not been able to reach out to the ministry, for which instruction cannot be obtained. Stop. Paragraph. The learned advocate is directed to take the assistance of the DSGI in this matter, so that necessary instruction from the ministry may be obtained and placed before this court on the adjourned date. Released on 22nd August under the caption Payment of Dues.
Number 12.
Yes.
Your Lordship, that matter, last occasion, Your Lordship was pleased to pass an order.
I am appearing for the
Pass an order. There, Your Lordship, kindly see Your Lordship's last order, August 4, 2025.
Yes.
Petitioner alleges that his son and daughter-in-law stay in the same house, regularly torture him, for which petitioner pays son and daughter-in-law be directed to move out from the said house, which consists of two plots. Allow the learned advocate representing both the parties to come ready with proper instruction for further consideration.
Are you there for the private respondent?
Parties shall private respondent. Madam, Your Lordship, from Your Lordship, shall third shall revert with instruction as to whether there is a provision for separate access to the plots and whether the petitioner's son and daughter-in-law can live separately in the said house. Yes, they can live separately. 2 floors. My instruction is this: one big room, first floor, and another in ground floor. That is the kitchen with washroom. Also, washroom in the first floor. We are ready to give my son and daughter-in-law.
Which portion would you like to occupy?
Yes, my lord.
Which portion would you like to occupy?
First floor 2 room, and second floor 1
Which
kitchen.
portion would you like to occupy? First floor 2 rooms and kitchen in the ground floor.
And also kitchen, separate kitchen is there. 2 kitchen is there in ground floor.
There is no kitchen in the first floor.
No, there is no kitchen in the first floor.
All right.
My lord, so far my instruction. Lord,
Yes.
in the first floor, there are 3 rooms. And there one kitchen room in the ground floor. My client and her husband are occupying 4 rooms. And the petitioners and his wife, they are occupying 7 rooms on the ground floor.
How many rooms are there in the ground floor? 7 rooms.
7 rooms, 8 rooms, kitchen, including kitchen. Including kitchen, 8 rooms.
8 rooms.
Yes, madam.
Whose house is this? Your father's house?
Yes, madam. My father-in-law's house. Madam.
Father-in-law's house. All right. Not your husband's house, at least.
No, no, no. My
right. Your husband is an employee of the railways. Right.
My lord.
Why can he not make accommodation for himself?
They are occupying sufficient space, Lord. There is no problem regarding occupation of space.
There is no problem, and you.
Their intention, my lord, their intention is to evict me by hook and crook, Lord, by filing different cases, Lord. I filed a case for domestic violence, Lord. Against that, Lord, order has been passed, an interim order. They also filed for filed case under section. Under the provisions of Welfare and Maintenance of Senior Citizen Parents and Senior Citizens Act. This is the interim order, my lord, in domestic violence.
Please don't show me the order. I am not looking into that. Thing is, you have to stay in a separate place so that regular infighting between the parties does not take place.
My lord, we are residing in the first floor, and we do not disturb and interfere in the access and in the movement of the petitioners. They are residing in the ground floor. They have sufficient rooms.
How many rooms? You have got 7 rooms?
No, 2 kitchen, ground floor, and 3 rooms, ground floor. And first floor, my lord, 3 rooms.
All right.
3 rooms.
If you
I'll
can
give you-
manage within the ground floor, you do not interfere with the first floor. Let your daughter-in-law and your sons stay separately, and you stay separately in the ground floor. No disturbance with each other. No interaction with each other.
আপনি কি নিচে তলাটা থাকবেন না উপর তলা থাকবেন? নিচে থাকবেন না, উপর তলা দিলে অসুবিধা নেই তো, সব কটা রুম ঘর।
The son and daughter-in-law, you all make arrangements in the first floor. Do not interfere with any portion in the ground floor.
Ground floor, my lord. If I'll give the entire first floor, I'll give to them. Then my daughter is there and others relatives are there. It's impossible for her to stay there. For which you, lordship, kindly accommodate 2 rooms. They will take first floor.
All right.
And 1 kitchen in ground floor.
No, they will not come down. You can manage in the first floor. 1 minute. You can manage in the first floor.
Yes, my lord, I am residing.
And you do not want the kitchen in the ground floor.
No, kitchen, I am also enjoying the kitchen in the ground floor.
You are enjoying.
Yes, one.
So, how many rooms, according to you, is there in the first floor?
First floor, 3 rooms.
All right.
We are enjoying.
Let
And wife
you
and
leave.
1 minor child.
You leave 1 for the petitioner also. You keep 2 first floor and 1 kitchen in the ground floor. That is enough for you. All right. And you have your sister-in-law also. They come to your place.
Yes, Lord, he must, he comes and he will come, Lord. That is.
Yes. So
No,
2
things
rooms.
I have no enmity against anyone, Lord.
2 rooms. You have no enmity and you file proceeding under the Domestic Violence Act. You file proceeding under the Criminal Procedure Code and everything.
My lord,
You have got no enmity.
I'll give
From
the
the-
rooms.
No, my lord,
All right.
one problem will be there, my lord. If one room is given to the petitioners, my lord, they will.
2 rooms will be given to you. 2 rooms in the first floor, 1 room in the ground floor for the kitchen. All right. Do one thing. You come up with your proposal, and he will also come up with the proposal. Let everything remain on record. All right.
To an affidavit.
By way of affidavit. Acha. Learned advocate representing the petitioner submits that the petitioner requires 1 room in the first floor for her daughter and her family to occasionally come and stay. না এটা কেটে দিন, আপনি লিখুন learned advocate representing the petitioner and the private parties submit that there is provision for staying in separate floors with different rooms without interfering in each other family matters. Stop paragraph. The parties are directed to file an affidavit disclosing their proposal to use the rooms. Stop. আচ্ছা ফাইলের জায়গায় prepare and circulate. Their consideration on 21st August, 2 weeks time. In between y'all settle it up. I'll keep it on record and dispose of the matter.
Another same heading, my lord.
Yes, same heading.
My lord, Mr. Hallar, others matter appearing code number 7, short pass over, my lord.
Okay. What is the matter about?
The matter was regarding, my lord, making some payment
All right.
for some work done for the state.
Yes.
Thereafter, my lord, the payment has now been released.
Now
Thereafter,
petitioner claims interest.
now they are claiming interest.
Yes.
At
In
the
the writ
get-go, my lord, there was no such vociferous argument with regard to interest.
in the writ petition, is there a prayer for
Prayer
interest?
for interest.
Yes. And the period of delay?
My lord, amount has already been paid.
The delay, the date of the money being falling due and the date of payment. What is your submission with regard to interest? If there has been substantial delay in payment, then the petitioner has rightly claimed interest. What
Lord,
can be done?
my legal mind asks me to make an argument that there is no crystallized date, etc., etc.
The
But
court
once
is not accepting your
at the same time, my lord, when the payment has been made,
Yes.
the officers have virtually accepted that some payment was due. So
Yes.
if I look at it from that perspective, it was his money in my pocket. But
And
my
you have
lord,
enjoyed it.
and my lord,
He has.
but my lord, problem is that my lord, without taking it as my concession, appearing for the state, my lord, I generally do not make these submissions, my lord. But I'm only saying, my lord, what it feels to me.
Yes.
So, my lord, perhaps, my lord, a reasonable amount of interest may be given to the
Banking interest, whatever is the banking interest. Reasonable means whatever is the banking interest. The court is not fixing up any rate of interest. Whatever is the banking interest is the date mentioned as to from
Yes,
when
my
it was due.
My lord, your lordship will find that in the supplementary affidavit, page 45, kindly takes. This is the document, my lord, which has basically gone against me, where I have certified that this amount is payable to him. Supplementary affidavit, page 45.
Yes.
Which were payments of 1920 and one payment was of 14. I in the initial stages I had made those arguments, my lord, I'm not repeating that. Your lordships were of the view that it can be given, my lord, if since we have certified, then this has been certified in 2022. During pendency of the writ petition, it has been paid. We are now in 2025.
Please come. The payment which was due to the petitioner has since been released. Stop. The block development officer, Mathurapur 2 development block, has certified the dates when the bills were submitted by the petitioner. Stop. The payment has been made after considerable delay. Stop. The petitioner prays for interest. Stop. As the money has been paid to the petitioner after a long period of time, and the petitioner was not in a position to utilize the money which was legally due to him. Accordingly, the block development officer is directed to pay interest at the banking rate to the petitioner on and from the date the money fell due till the date of actual payment.
Well, for that one payment will be of 2014. But let it be from the certification, my lord.
You accept it from 2014.
My lord, they have, my lord, consider.
Take rest. Take rest. Don't go out of breath. Acha. He will not. The date of actual payment. Step shall be steps for payment. Steps for making the necessary calculation and subsequent payment shall be taken at the earliest, but positively within a period of 4 months from the date of communication of this order. Writ petition disposed.
Yes, petition. Yes.
Kindly see your lordship's order dated 16th of July.
This will be the last matter prior to recess. Thereafter, one matter in camera will be taken up. The counsels are requested to please leave the courtroom. Yes.
Kindly see one lordship's order dated 16th of July.
Yes. Petitioner is a senior father, gifted to his sons. Sons?
Madam.
Yes. Learned tribunal is here for the state. All right. Direct the sons to
Earlier occasion, there was a direction upon the Arambagh police station to
ensure that the private land of the petitioner is not cultivated, being sons are restrained from occupying or using. What happened?
In the meantime, my lord, they challenged your private resident challenged your lordship's order before they lost. Or kindly see the appellate court's order.
Yes, my lord, the appellate court says they.
My lord passed. And so, my lord, confirm this order and permanently extend the private response.
The appellate court says since it's an interim order, appellate court is not interfering. I took the point of maintainability. If your lordship allow me, even now, my lord, I can point out that.
Yes.
My lord, so, my lord, if your lordship allow me to speak about the maintainability, I will say that. Otherwise, my lord, if your lordship want to confirm this, then my lord, I will have two requests. One, my lord, since your lordship is setting aside the order of maintenance, kindly, my lord, say that further we don't have to pay maintenance, since, my lord,
That is your legal obligation. You are required to maintain your father.
no, my lord, here the challenge is order of maintenance. The challenge itself is the order of maintenance. Now, my lord, the lordship says since, my lord, I am occupying the
Your
father's
father's
land,
property.
my lord, the order is that since I am occupying the father's property, so I have to pay maintenance. My lord, so if your lordship is setting aside the order of maintenance, and, my lord, imposing this, my lord, then, my lord, I have to give maintenance as well as this. So, my lord, if your lordship is sending back this, then, my lord, the order of maintenance will not remain. Otherwise, my lord, kindly see the challenge in the petition. It is only the challenge of the
submit a report in details after inquired by the PTO.
Yes.
order of the maintenance tribunal is the challenge before your lordship.
So far, maintenance order, I have no objection, madam. I have no claim also.
So, my lord,
1,000 rupees per month.
Yes.
What will the petitioner do with only 1,000 rupees per month?
My lord, once it is granted 1,000 and 1,000, 2,000 rupees.
What will a person do, a senior citizen, with 1,000 rupees per month? His medical bills will be more than that.
my lord, kindly come to
But
the
the
order
report
for
of- the
once.
report has
He is
already-
having
One thing,
85 lakhs.
1 minute. Tell me one thing. If the land is returned to you and he is not cultivating it, he goes out of possession, will you still require maintenance to be paid? You only 1,000 rupees, you do not need 1,000 rupees. Isn't it?
Yes, yes. Yes, yes, yes. Your lord.
So if the land is given back to you,
Yes.
you do not have any claim for maintenance against your son.
Madam, already some portion I have gifted.
That is separate.
Yes.
That what you have gifted is you are not wanting that back,
No.
right?
No.
You only want your land to be
On
given
my
back
possession,
to you so that you can utilize it for your own use.
Yes.
This is the thing.
Yes.
He is agreeable to forego the maintenance amount.
All right.
All right.
All right. All right. And, my lord, only the land in the name of my father, because my
Obviously.
deceased mother is also having some land we are cultivating. Now, my lord, taking the situation of this thing, my lord, the entire property.
If your deceased mother had some land, your father also had his share over there.
No, my lord.
I have gifted that
my
share, madam.
my father, after
share.
the death of my mother,
All right.
Share of
my lord, my father, after the death of my mother, at the age of 73, married another lady. She is having 5 sons of the first day.
You have a problem with your father marrying somebody else?
No, my lord.
Why? You
Because-
should not.
My lord, my father is gifting all the
Tell that-
property to the wife's first husband's son. My lord, that is what the problem is. My lord, I also having my
His
son.
property, sir. Let him enjoy it the way he
Let him
wants.
enjoy, my lord, I don't have any.
You have your property. Depend upon that.
Yes.
Acha. The judgment dated 29th July 2025. Passed by the Honorable Division Bench in Mat Atto, challenging the direction passed by this court on 16th July 2025, has been placed before this court. Stop. Learned advocate representing the private respondents submits that the private respondents are willing to hand over possession of the property which is recorded in the name of their father, provided the father does not claim any maintenance from them. This is exactly your submission. Paragraph. Learned advocate for the petitioner admits that the petitioner will not claim any maintenance from his sons, provided the lands which are recorded in his name are returned to him. Stop. Paragraph. Learned advocate representing the state respondents has placed before this court a report of the subdivisional officer Arambagh Hooghly, wherefrom it appears that the subdivisional officer has directed the sons of the petitioner to deposit a sum of rupees 1,000 per month to the savings account, to his savings account. Stop. Paragraph. As the petitioner has submitted that that he will not require the maintenance amount, accordingly, the direction passed by the subdivisional officer.
My lord, subject to correction, my lord, they went to appeal. My lord, kindly come to 84. It was enhanced to the extent 1,263. My lord, they have challenged that.
1,263.
263 rupees enhanced.
How come 63 the officer calculate?
My lord,
Is there any mathematical calculation?
crops? Valuation of the crops and divided. My lord, 84 with page 84.
Page 84.
No, 15.
84.
No, 59.
তাই বলো 59 আচ্ছা কি বললাম ওখানে একটা সাবডিভিশন
Oh. No, in my copy it's 84.
Subdivisional officer modified by the order of the district magistrate,
Yes, ma'am.
directing payment of rupees 1,263 per month, loses its force. Stop. The writ petition is disposed of by directing the private respondents to hand over peaceful vacant possession of the petitioner's personal property to him so that he may use the same for his personal maintenance. Stop. How soon?
But that has already been taken by the police.
No.
Police taken?
Police is waiting for the final order, madam.
My lord, immediately, your lordship, kindly see, my lord, it is not in my position. Immediately seize.
ঠিক আছে
Madam, kindly
the give দেখি learned advocate representing the state has produced before this court the instruction from the inspector in charge Arambagh police station signed on 5th August 2025, wherefrom it appears that the police has kept strict vigil to ensure that the private parties do not cultivate the land of the petitioners. Stop. The police is directed to ensure that there is no breach of peace at the locale and the petitioner is able to use his personal land for his personal maintenance.
My
Disposed.
lord, may I prefer one line only? The my father's property, because the
I have recorded in each line that it is only the property
but
recorded in the
police
name
has
of your
already
father.
taken away my mother's property also. My lord, they have.
I do not know. Call the